International courts. To date, there are 3 permanent regional courts that exist as supervisory bodies specifically for the implementation of human rights: the European Court of Human Rights, the Inter-American Court of Human Rights, and the African Court of Human Rights, ACHR. The Inter-American Court of Human Rights was established by the Organization of American States in 1979 to interpret and enforce the American Convention on Human Rights. The African Court is the last of the regional courts established in January 2004. It resolves cases in accordance with the African Charter on Human and People's Rights against member states of the African Union. The judges of the court, based in Arusha, Tanzania, were elected in 2006 and it delivered its first judgment in December 2009. The International Criminal Court. After the ratification of the Rome Statute by 60 countries in 2002, the first permanent International Criminal Court began to operate, considering cases related to war crimes, crimes against humanity and genocide. This International Criminal Court hears cases of persons accused of crimes against humanity, genocide and war crimes, but only if national courts are unwilling or unable to investigate these crimes or prosecute them. To date, the IC has investigated 5 situations in northern Uganda, the Democratic Republic of the Congo, the Central African Republic, Sudan, Darfur, and Kenya. His pioneering case law has helped advance the understanding of human rights, for example, with regard to incitement to genocide and the right to free and fair elections. The International Court of Justice. The International Court of Justice, IC, is the main judicial body of the United Nations. He has a dual role: to resolve legal disputes referred to him by states in accordance with international law, and to give advisory opinions on legal issues. Only states can bring a case against another state, and usually cases concern treaties between states. These treaties may relate to basic relations between states, for example, commercial or territorial, or may relate to human rights issues. The IC does not allow individuals to make human rights claims or other claims against it. However, he has promoted human rights by interpreting and developing human rights norms and principles in cases that have been referred to him by states or international bodies. It deals with such rights as self-determination, non-discrimination, freedom of movement. The role of the European Court of Human Rights, ECHR, the European Court of Justice, ECJ, and the International Court of Justice, IC, is often confusing. In fact, these 3 bodies differ greatly in their geographical jurisdiction and the types of cases they handle. The European Court of Justice is an organ of the European Union. It is a court whose primary responsibility is to ensure that community law is not interpreted and applied differently in each member state. It is based on community law, not human law, but sometimes community law can touch on human rights issues. The International Court of Justice, IC, is the main judicial organ of the United Nations, and its role has been discussed above.